20 years ago, Kentucky closed its last large children's institution. This facility, known as Kentucky Village, which had been designed to accommodate 200 children at one time, became home to almost 1,000 children, ranging in ages from 6 to 21. Kentucky Village and facilities like it across the nation represented one of the traditional practices of rescuing children by removing them from their homes for treatment, correction, or protection. With the closing of Kentucky Village and other institutions, the department adopted a philosophy of removing children from their homes only as a last resort. However, the all-too-frequent tradition of separating families by sending children away continued.
Hello and welcome to another edition of Inside Family Court. My guests today are Chief Judge Richard FitzGerald, the Chief Judge for the Jefferson County Family Court and a nationally recognized expert on child welfare issues. My other guest is Stephanie Trenaman, who is the Recruitment Officer for the Cabinet for Families and Children. Judge FitzGerald, Ms. Trenaman, thank you for joining me today. We've just watched a segment that gives us quite a different picture, Judge, of children who are in placement than what we have now, haven't we?
I always think it's interesting, particularly when there are groups of children who are raised in orphanages or in children's home, when they come together to talk about how many of them have become parents of choice and their experiences in institutional care. I went on the bench in 1975, and many of the reforms that have been done in terms of placement of children, improvements in foster care and adoptive homes have come about because of reform efforts both in the judiciary and within the Cabinet for Family and Children's in recent years, including a commitment to permanency and safety for all children who are subject to court action for maltreatment.
Well, let's talk about where we are now. How does a child come to be available to be adopted?
Well, children are free to become children of choice by adoption, either through the voluntary relinquishment of parental rights. And there are many times where an individual believes it's in the best interest of their child that they relinquish their parenting authority and power to a third party who wishes to take upon themselves a permanent relationship for the child. There is another process for children who are subject to proceedings for abuse and neglect where there cannot be reunification for the child safely within the context of family, where there's been a proceeding for the involuntary termination of parental rights, and the child post-termination of parental rights is free to become a child of choice.
Typically, who initiates these petitions for involuntary termination?
The petitions for involuntary termination are filed by the Cabinet for Families and Children for their children, most of whom are in foster care, some who may be in relative placement. But they can also be filed by the county attorney or Commonwealth attorney.
On an average, do you have a sense of how long under a involuntary termination situation that it takes to go through that part of the process?
Part of the reforms of this administration and part of the President Clinton's Adoption 2002 initiative and the congressional initiative on the Adoption and Safe Families Act has moved the cycle of permanency planning from what used to take an 18-month period of time down to a 12-month period of time. So you have that period of time to go through the initial abuse and neglect proceeding. Then there would be a filing for termination of parental rights. That process, that trial, by clear and convincing evidence, a high standard of proof, would take approximately another 8 months, and then the child is free within the process of recruiting and certifying and matching that child with an appropriate adoptive family.
Thanks, Judge. When we come back from break, we'll talk about where the children are during this process. Thank you. Welcome back to Inside Family Court. Stephanie, during this process, the children have been removed from the home, as Judge FitzGerald has said. There is a petition for involuntary termination pending. Physically, where are the children?
The majority of those children are in family foster homes. These family foster homes have been recruited, trained, and certified by the Cabinet for Families and Children.
While they're in the foster home, what's happening? What kind of services, if any, are they getting, and what does their life look like?
Typically, these children are dealing with loss and separation issues. Our foster parents have been trained through the certification process to deal with these issues, as well as some testing behaviors. We also give our families the skills to manage those behaviors. If there are issues that are not able to be managed within the family foster home, the Cabinet for Families and Children will refer that child to outside services.
Give us an idea of how many children today are available for adoption and right now sitting in a foster home.
There are 583 children whose parental rights have been terminated. Of that number, 365 of those children are available currently for adoption through our special needs adoption program.
Judge, we all think we know what adoption means, but give us a good legal working definition of adoption.
Adoption is a process where there is a legal assumption by the creation of a parent-child relationship of the duty to nurture, support, educate, and protect a child. An individual literally becomes a parent by law, and part of my order will read the same rights as if a parent by birth and blood of the child. Historically, adoption actually was an adult-to-adult relationship that had to do with inheritance. And child adoption or infant adoption, particularly that where it talks about the best interest of the children, became somewhat of a uniquely American phenomena of about 100 years ago. The process of reforms that have gone on in Kentucky now include, wherever possible, when we recruit a foster home, to recruit it as a resource home which both can foster and potentially adopt the child if the child becomes free. And one of our goals is that a child experience a single, stable placement from the point of entry into the system to the point of safety and permanence.
I think that one thing that we hear more and more of lately is the concept of private adoptions. Can you kind of just briefly compare and contrast the private adoption scenario versus what we're really talking about today?
Well, I think when people talk about private adoption, I think about relationships through private counsel or independent adoption agencies. The most common adoptions are step-parent adoptions, where a step-parent adopts the child of their wife or husband. The next are infant adoptions through children who are voluntarily relinquished to an adoption agency or to an identified party. And most of those are done through private agencies. What we're talking about today, and particularly the reforms in the Cabinet and in family court, are those cases where the children have been abused or neglected, and they have the trauma of the impaired parenting and the additional harm that's been done by foster care drift and unnecessary delays in the court system.
Stephanie, I've always been kind of interested in maybe adopting a child. What's my first step?
Your first step is to inquire with us. You can call us at 595-3114. We offer information meetings twice a month, and if that doesn't fit someone's schedule, we can schedule a home consultation to let people know about our program. That would be the first step. Then we have a 10-week preparation training class that offers 30 hours of training.
Go ahead.
Some of the basic requirements are that individuals be at least 21 years of age. You can be married or single. We ask that you have a stable living environment, which would allow for the child to have suitable sleeping arrangements. We ask that you have a stable financial situation. And when we're looking at that, we're not looking at a set amount of money. We're just asking that you can meet the needs of your family. We ask that the applicant be physically and mentally stable, and they are asked to complete a medical form that's signed by their doctor. And again, you have to complete the 10-week training course.
How long typically does the investigation or form application process take?
We typically say that from the date that they come for the information meeting, which is the first step, it takes 4 to 6 months to get them approved and certified.
Okay. I've been approved, I've been certified. What's the next step?
At that point, a family or individual would look through our book of children that are waiting for adoption, and if they were interested in a particular child, they would submit a referral of interest. At that point, the workers involved with that child would meet with the family, And the Cabinet's very open and honest about the issues surrounding this child. If the family is still interested in that child, once they hold a conference and discuss the child, there are certain steps that will lead to actual visitation with that child.
Thank you. Judge FitzGerald, we are in a climate where we have seen a tremendous increase in the activity of grandparents and grandparent rights in terms of their grandchildren. What happens to those rights in an adoption termination setting?
In a termination setting or in the adoption proceeding, there is a severance of rights of the biological parent. If a grandparent has, prior to the order terminating the parental rights, legally established grandparental visitation, that grandparent's rights goes past the termination to be able to maintain contact and visitation with the child. I think there are a number of cases also because with our child welfare children, our older children in particular, they may have a good positive contact with a grandparent who was protective of them but is physically or financially unable to nurture, support, and educate them. And in many of our child welfare adoptions, because of the fact that children do have a sense of self and place and community, there is, in reality, an open adoption where the child, under the guidance or in the context of the protection or the protective choice by the adoptive parent, maintains some contact with the biological family with the permission of the adoptive parent.
When we come back, I want to talk about special needs adoptions and the power of children in adoptions. Thank you both. Welcome back to Inside Family Court. Stephanie, what about special needs children?
The majority of our children who are in the special needs adoption program are white children over the age of 10, black and biracial children over the age of 3, children with moderate to severe emotional, physical, or mental disabilities, and these are children of all ages, and then sibling groups of 3 or more.
The criteria of special needs adoption actually came about because these were the children who tended to linger too long in care with multiple moves and placement. And the Cabinet and the country has made a commitment to support the adoptive placement of these children so they don't linger unnecessarily in care. One of the big changes in consciousness is the fact that instead of a child saying this is a hard-to-place child, it's the true belief that all children are adoptable and there's no unwanted children, there are unfound parents.
Judge, are there subsidies available for the folks who adopt these children?
Well, I think, first of all, the function of protection of children and adoption is not just the function of the agency and the courts, it's the duty of the whole community. So on a large group, there should be community benefits available for parents of choice or adopting parents through regular employment benefits. There are also parenting support groups or parent support groups for children, for parents who adopt, and for children who are adopted in terms of coming to dealing with the issues of attachment that they deal with. Now, there are the classifications of children as special needs adoptive children. The federal government and the state provide a subsidy for adoption at the same level as if the child was in foster care. So there is a subsidy that is available, and there are other supports available to deal with some of the emotional problems. One of the things I think the Cabinet has done in recent years, which is a vast improvement, is give a very, very good presentation summary, a very honest presentation summary regarding the children who are available. So the person making the choice and seeking a match really does get a good feeling and a good sense of the history of the child.
We've talked kind of about the parents when we've talked about termination and about adoption. Stephanie, what about the power of these children who are going to be adopted? They go out on their first trip with their maybe future parents and they say, you know, it didn't come back, didn't go so well. How much power do they have in this process? Certainly.
We recognize that children are going to have anxieties that come about as a result of visitation with their prospective new parents. So we're certainly going to listen to the concerns that that child has. We're certainly going to check with the child and see that they're comfortable and actually give them a voice in the adoption process.
Judge, here's some talk around the courthouse here over the last week or so about Adoption Wednesday. We're running out of time, but can you touch
Adoption Wednesday is a collaborative project between the Cabinet for Family and Children's and the Family Court. We recognize that there were a number of children, in excess of 80, who were in foster homes already, and arrangements had been made that they are going to be adopted by their foster parent. But their cases had not been scheduled for a final hearing to complete the adoption. And we decided that, since many of these children had been Wednesday's children, that we'd clear the dockets on a Wednesday afternoon in September and schedule and provide, with the legal support of the bar, for as many of these hearings as possible so we can finalize them on that date in September 22nd.
I think we've got, what, 40-some teed up right now?
There's 46 slots that are prepared for that day, and there's about 80 that are already in the works.
Tell us about the future of adoption.
We, obviously, because of many of the reforms of the system, there's going to be an increase in filing for termination of parental rights. The agencies and the court systems are not going to work with families for as long. There's a point where they have to make it safe, or we're moving on to safety and permanency. Because of that, we're going to need to go out to the community and recruit and explain and have the community come in and meet these children and participate. I think we'll do that by developing resource homes so that the same home fosters and, if necessary, adopts. We need to look out in the communities and to look at the rates that we, in fact, have been paying foster parents. I've always found it somewhat amazing that we can pay an institution hundreds of dollars a day for a child when the foster parent is raising the child for $15 a day. Yet it's the same child, as they may come in and out of institutional care.
Judge FitzGerald, Stephanie Trenaman, thank you for being on Inside Family Court today.